We are still waiting on quite a few people, but hopefully they will just join us here in the next couple of minutes. But let's get started this morning. I know we have a lot of stuff to cover in an hour, so I want to give us as much time as possible to do that. For anyone that doesn't know me, I am Amber Sheeran. I'm the Program and Events Director with MLA, and we are so happy to have you at this webinar today. This is a part 2 webinar. Library of Michigan hosted the first part. We're hosting the second part, talking about the Privacy Act amendment. So welcome everyone this morning for joining us. As always, please keep yourself on mute unless you are unmuting yourself to ask a question. That way that we don't have any distractions in the background. And utilize the chat box to comment or ask any questions as we go. And I think that is really all the housekeeping information that I have for you. So with that, I am going to turn it over to our speakers today, Claire Mambiela and Ann Siernick.
Okay, Debbie, do you want to start off? I'm going to share my screen here.
That sounds great.
Oh, I don't have the ability to share.
I'm going to get Amber. Are you taking care of that? Okay. Wait just 1 minute so we can.
Okay.
For some reason, it's not allowing me to let Claire do that, so I might just have to share the slides for you.
Okay, no problem.
Little changes on the fly. Okay. So just let me know when you need to advance, and I will do that for you.
All right, so thanks for joining us this morning. I know that we've covered a lot of this information during our last session, but we wanted to make sure that those of you who wanted to know a little bit more, there's a few things that we want to make sure that you're aware of, and we're just really pleased to have you joining us today. So Amber, you want to change that slide up? And then next. And then next. That's Claire's disclaimer. So we'll go back to that if anybody has any questions about what's going on with that. So, but I will point to Claire and to Anne, and they are very clear about making sure that whatever you do within your own library, that you make sure that you're talking to your own attorneys. And I know that they will say that about 100 times today. So. Just really briefly, we want to just talk about the Michigan Library Privacy Act. And we were, libraries are one of those legal entities that we're unable really to provide law enforcement with timely information. And sometimes, and I will say this kind of clearly, is that sometimes we all felt, many of you have felt that you were hostile witnesses to crime that was happening within the library, and we're not able to share information with law enforcement if a crime was committed. So what we've taken right now is this was a 40-year-old law when it was put into place, and before we started to make updates to it. And the language was really very unclear. And I think that many of you had looked in on this over the course of many years, and just wanted to make sure that it clearly stated, as we know, there are some things that have changed with technology, and with just making sure that 40 years of having cell phones and the capability of video surveillance and things like that. The Library Privacy Act didn't really address any of those things. So it was very nebulous. It was very, there are no court opinions or court interpretations of the Privacy Act, because there have been no suits that have come across. And I will say that as MLA started to look at this, libraries across the street from each other actually had differing opinions. Their attorneys had differing opinions about how to interpret what is a library record, what is, you know, how do we start to look at the contractors that we're using, what, you know, how do we use how do we use this video surveillance? And again, a library 5 miles up the road would have a different interpretation, and that was causing a lot of miscommunication amongst patrons and amongst all of us who are helping to, you know, to serve libraries in this capacity. Everybody was talking a little bit of a different language. So next slide, Amber. So in the fall of 2019, MLA was approached by a library director here in Michigan that had concerns over the Library Privacy Act. And by October, so between the fall, say it was probably maybe, you know, September 30th, and between September 30th and October 31st, we only had one legislative and advocacy committee meeting. We didn't have a lot of conversation about it. But on October 31st, Senator McGregor, who represents the Kent County area, proposed legislation to update the Privacy Act. And really the proposed language, it was a Senate Bill 611. It wasn't vetted by MLA. We had no input in the drafting of that initial bill, which is what we would like to make sure that we always have the ability to get your input, get the full state input into a bill if we're being proactive over something. And this was this was being proactive to make changes, but we just had not vetted anybody. We hadn't vetted any communication about, is this good? Is this bad? Is this, you know, what is this? So we were kind of handed a bill. We were handed the initial bill, and we took that, and between December 2019 and February of 2020, we surveyed the MLA membership, we gathered the input, we enlisted the help of the American Library Association, their chapter relations, and their attorney and we finessed the language. And I think we came out with, maybe I'm wrong, but I think there were 3 substitutes by the end of the day, by the end of December of 2020. I think we had 3 substitute bills. So we're really, I think we're making sure that you know, within all of that, it had to go through the processes, and we kept, I think we kept coming back to continuing to finesse that language. And it was really important to us that, you know, we had to go through the Senate Judiciary Committee, and then we went for a Senate vote. And then, of course, in March of 2020, you all know that COVID hit, and everything stalled. Everything just went, you know, kind of quiet for a little while until October. When the Senate Judiciary Committee took it up again, and then we had the formal vote. In November and December of 2020, the House Judiciary Committee then took it up and had a House vote. And we had some changes happening right at the end to make sure that were proposed by the ACLU. They were one of the only organizations that had just a slight issue with the language, and we cleaned it up. As you all know, it went into effect, the governor signed it on almost the last day of the session, and the law is to take effect in 90 days. So coming up here really soon on March 28th, 2021, this bill, this act will now go into law. So next slide, Amber. So part of what I think a lot of what we really want to make sure is that we were balancing the protection of privacy, the things that you value, the things that libraries value, which is so is the information of what they choose, what they read, what they're, you know, what is in what is in their record. And we were really trying to make sure that that we were protecting that and making sure that nothing happened within the act to change that. So we were really very cautious, very careful about what we were trying to you know, that what we were holding that value. So next slide. And what we ended up really talking about is that we knew that change was needed, but we really wanted to clarify a number of things. And so one of those things was when that was passed, we weren't sharing a lot of content. We weren't using our, you know, we weren't using the, you know, I assume co-ops were still doing that, but now we're using a lot of technology, and a lot of that information policy that 40 years ago might not have existed. We're now kind of in the middle of that. So, and new realities of crime, and more services. We have more valuable items. You know, the libraries are loaning out laptops and hotspots and bicycles and tools, and there's CDs and audio tapes, and we really wanted to make sure that those things, if those were stolen and that a crime was committed because of those items, that we had the wherewithal to change that. So next slide. So I think that there were probably 5 things that happened that we were really conscious of changing. And we wanted to make sure that we updated the definitions. What is crime? Who are law enforcement officers? And we really took, I think part of our work was to make sure that we were defining those things according to other laws that were already in existence. We wanted to clarify that surveillance videos were not included within reading records, and making sure that if they're turned over to law enforcement, that there didn't need to be a court order for surveillance videos. So the law stayed the same though for other things. We wanted to clarify just personal knowledge, that you all have personal knowledge of you know, individuals' names, and that could be also turned over. And we wanted to make sure, I think the big part is that we wanted to make sure that the liability and what those consequences are for the violation, but also then the liability for the library and for whoever was talking or was sharing that with the police, were able to share that without horrendous consequences. So within the law, within the act, we were trying to clarify a number of things to make sure that, again, third-party vendors and others were affected in the very same way that libraries were. So next slide, Amber. So I'm going to turn, I think the detail is going to come from the professionals. So Claire and Anne have the meat of this, but we're really, I think we're making sure that, you know, we want to make sure that you have as much information before the March 28th date. We made sure that we put that 90 days in there so that we could provide enough education for you to answer questions and to be ready for that and to update your policies and procedures. And so Claire and Anne are going to talk through all of those kinds of things for you. And hopefully at the end of the day, you feel comfortable with the changes that are going into effect, and can continue the good work that you do. So Claire, I'm going to turn it over to Claire.
Okay, thanks a lot, Debbie. Okay, so Ann and I are going to discuss kind of the overview of what these amendments actually do and what kind of the expectations are for on the ground, so to speak. So you can kind of break them into 3 different categories. And before I kind of delve into that, I want to mention that, you know, the Library Privacy Act is kind of broken into 2 halves. One half is the half that we're discussing today, which has to do with the disclosure of information and protecting patron records. The other half has to do with the exposure of children to sexual or obscene content. We're not going to be dealing with that second half today. The amendments that were passed do not address that part of this act. So we're not going to discuss that today. We're going to stick to the privacy of information portion. So if you would advance the slide for me. So when we talk about definitions, definitions in a statute are very important, and I talk about this a lot. When you're going to read legislation or you're going to read a statute, one important thing to remember, and this is going to sound stupid, but statutes are words and legislation are words, and those words are really important because especially when you're dealing with a statute like this, where there's very little court cases or very little legal authority to kind of direct your attorney or direct you on exactly what the statute means. Generally, you know, you would look at, you know, what is kind of the common meaning of the word. The exception to that is if the legislature has actually put a definition of the word in the statute. So it's really important that when you're reading a statute, you take time to look at that first section that says definitions. And you know, the bigger the statute, you know, the bigger the definition section. And sometimes it's tucked way at the beginning. Like if you look at something like, you know, the criminal code, or you look at something, you know, a very large act, the definitions are all going to be at the beginning of the big act. But they become very important as you read through because, you know, it's a lot of times you have specific questions about, well, you know, what does this mean? And in the context of this law, some of these definitions over the years became very difficult to figure out. So this amendment specifically deals with the definition of crime, the definition of law enforcement, and the definition of library record within the definition section. There are some additional definitions that are sprinkled within the text of the language that we're also going to discuss as we move through. But these 3 definitions appear within that definition section, and they do not appear within the text of the law. So in order to understand what these 3 terms mean within the context of this law, you would have to read within the definition section. So if you're ever reading any of the library statutes or any statutes that have to do with your library and you look at it, you say, geez, you know, what did they mean by that? The very next place you should go is the definition section. It won't always have the answer, but many times, you know, it will. It's a very, you know, it's something very important that you want to take a look at. If you would please, next slide. Thank you. So when we first talk about crime, you may think to yourself, well, you know, geez, I know what a crime is. And this becomes very important in the context of this particular law, because many of the permissions that you get to release information come, you know, as part of a crime being committed in the library. So it's important that you know, what does a crime mean? And the term that the legislature adopted is the term that is also in the penal code or the criminal laws. And it says, you know, I have it on the slide here, it's an act or omission forbidden by law, which is not designated as a civil infraction. So, you know, for example, a civil infraction is like a traffic code or a traffic infraction. And then it lists certain penalties. The reason why this could be important is when you're deciding whether or not to disclose information to law enforcement, you want to be careful, and you want to make sure that your staff is trained to understand, you know, that what a crime is. because, you know, you may think something rises to the level of a quote unquote crime. And in fact, you know, possibly it does not. So that is something that maybe if you're unsure of, you may want to discuss with your attorney as you're drafting your policies, because that could become you know, something very important that, you know, you don't want to lead your staff astray into reporting things or reporting people and providing information based on circumstance that really isn't a crime. Would you go to the next slide, please? Law enforcement officer. So a law enforcement officer in the context of this particular statute is an individual licensed under the Michigan Commission on Law Enforcement Standards Act. And then it lists police officers, sheriff and sheriff deputies, college and campus police, tribal law enforcement, and fire arson investigators. Notably, people like school principals or school officials are not listed here. So I get a lot of questions where, you know, truancy, if you have a, you know, a school contacts the library and wants to know if they know where a particular kid is. If you do come in contact with this kind of situation, that's something that you might want to discuss with your attorney, because arguably, you know, information on, you know, a particular kid's whereabouts may or may not be something that you want to disclose to a school official, since they're not a law enforcement officer, and they may not, you may not have the same release from liability that you would if it were a law enforcement officer, again, under certain circumstances. Would you bring the slide for me? Thanks. Library record, and this is the big one. As Debbie mentioned, there has been some discussion as to whether, you know, surveillance video is a library record under the former definition. So the definition has always said that, you know, it's a document record, etc., that personally identifies a library patron, including the patron's name, address, or telephone number. And you know, one of the discussion was always, well, surveillance video, I personally identifies a library patron if you can recognize the library patron. So if you can recognize a face, that arguably is personally identifies. There's another school of thought that disagrees with that. So that's kind of where some of this disagreement between, you know, attorneys and between legal opinions were that, okay, this is a library surveillance footage is library record, or surveillance footage is not a library record. So what this definition did, the change did, is it specifically identifies recorded video surveillance images made solely for security purposes are not a library record, as long as these images do not include activity or documentation or record that identifies a person as having requested or lawfully obtained specific services, materials, or information resources. For example, if you have a surveillance video that captures a computer screen of someone who is sitting in front of a computer, and it captures in detail what they're looking at, so you can recognize what that patron was watching, and that patron is not the patron that you are, you know, seeking the video recording for, you know, so that's not the patron who is causing the trouble or who allegedly, you know, committed the crime. It's someone else. Well, that particular portion of that surveillance video would be problematic to share. You would have to have it redacted. And there are methods to do that, and you can discuss that with your attorney. So part of this is not just handing over video footage, just like other documents that you would hand over that people would request, you have to review them and make sure that they don't include information that cannot be, you know, handed over. You also a library record would not include material that, for example, data that your circulation statistics, maybe statistics you use for collection development or weeding, how many times has a certain book been checked out, what are the popular genres in your library, how many of your patrons like mysteries, how many of your patrons like, you know, take out picture books or children's books. That data, as long as it's not connected to specific patrons, is also not considered a library record. So all of those things like interlibrary loan statistics and stuff like that would not be considered library record. How many people enter your building? would not be considered a library record. Could you please, thank you. So for example, as I mentioned, anonymous circulation stats are fine. You know, as long as it doesn't have data, as long as it doesn't have names attached to it, you should be pretty much fine. You can advance the slide. And as we mentioned, surveillance footage, as long as it does not contain images of forbidden information. So as long as it doesn't contain, you don't want an image of a list of the schedule for who's on the for who's going to get on the computer, right? Or if you have a patron standing at the desk checking out a book and you can clearly see the book and you can clearly see the person, you wouldn't want that to be shown. If you're looking at the back of a person and they're checking out a book, arguably that would be okay. So, if we have an example of a patron, you see a patron stealing a computer equipment and you can see them leaving the library with the computer equipment, but they walk by a legible computer screen. Well, that legible computer screen would have to be redacted in order to turn that footage over. Okay, you can, thank you. So the surveillance was a discussion after the last time we had this in January, we presented this. So surveillance footage, if it's not considered a library record, okay, again, as long as it doesn't contain any identifying information or any information that would disclose the reading habits of people, that footage, if it's not a library record, then it would be available for request under FOIA, okay, just like every other FOIA-able document in the library. Now, if you look at the retention schedules, which those retention schedules are pretty much, that's kind of the material you have to keep for purposes of FOIA. Currently, surveillance footage is required to be kept for 60 days, for 2 months. The Library of Michigan and MLA and Anne, actually, we kind of all got together and we discussed this because several libraries came to each of us with concerns about this, because it can be very expensive to have to retain your footage for a large amount of time if you have to buy extra server space, depending on how your security system runs, right? Some libraries were very concerned about this. So as a group, we went and we talked to the manager of the records, who are the people that hold these retention guidelines and create these retention guidelines. And we put in a request to change these guidelines, and they accepted our request. We requested that they would reduce from 2 months to 7 days. So far, we haven't heard anything negative about that. Our request was accepted, and we're very hopeful that these will be in place so that that retention guideline will reduce to 7 days. And hopefully we will have some kind of clarification on that before this law goes into effect at the end of this month. Debbie, have you heard anything more on this? No. Yeah, we haven't either, but maybe I'll put in a request to ping them to see if they can let us know. But hopefully we'll know by the end of the month. So we are very confident that this will be reduced to 7 days instead of the 2 months, which means that you would not, if in fact this does go into effect, you would not have to keep it 7 days. I mean, you would have to keep it 7 days. You have to keep your surveillance footage 7 days. Could you keep it longer? Yes, but you would want to talk to your attorney about that, because anything you kept longer would be open to FOIA. So that's a consideration that you would want to make with your legal counsel. Would you go ahead and advance the slide? Okay, so when we talk about specifically disclosure of records, so it is still a fact that the general records of the library, so patron records, or things considered to be library records, cannot be disclosed without permission, so without written consent, and it's still the person liable for payment or return of the materials. So this still includes parents are still responsible for children, right? So parents still would have access to children's records. However, there's been some additional subsections put in here, right? So you cannot, unless you have written permission, you cannot disclose unless a court has ordered it. So you have a warrant or a subpoena, or it is permitted under this new subsection 5. So new subsection 5 says that a library or an employee or an agent of a library, now notice that they put that in 3 different parts, right? A library, the entity, or an employee or an agent can disclose library records without a court order or the written consent if one of these 2 things apply. So one would be that if you have a contract with a collection agency, you can report that information that somebody has materials overdue to that collection agency for them to try to get the material back. Now, this is something that a lot of libraries have already do, but it's, and we've always, you know, as attorneys or, you know, your library's attorneys have always considered that to be an agent, right? Because an agent is generally somebody who's contracted to work with an entity under their kind of, with their permission or with their authority. And so that's kind of been the idea why collection agencies have always been kind of okay, quote unquote, with the Privacy Act. But it's never been really clear because, again, there's never been a court case on it. So this actually makes it very clear. So everyone can kind of breathe a sigh of relief that you don't have to worry anymore that your collection agency, if you use collection agencies, it is perfectly okay to give them the necessary information. But you can only give them the information necessary to get the material back. So you can't just, you know, disgorge records onto them. You can only give them the information that is absolutely needed to get the material back. So it's kind of like the rule here is you want to give the least amount needed in order to get your material back, or the least amount needed to, you know, report the crime. So kind of, you know, discretion is the better part of valor. If you want to err on the side of not giving more information than you absolutely have to, or the library or employer or agent, you can disclose records to another library or library cooperative for the purpose of conducting interlibrary loans. Now, same thing. If you, you know, the interlibrary loans would be what? The name of the patron, maybe their barcode, plus the information that they're looking for. You have to limit that information to the least amount required for getting that interlibrary loan. Again, it's not an excuse to shove every information about this patron to the other library. Do you mind advancing the slide? So one of the things you want to be careful of is that disclosure limited for information needed for ILL. Go ahead and go to the next slide. I get this question a lot, well, fair amount, on whether libraries who have reciprocity can share information of a patron who has a troublesome borrowing history. Sometimes it's even libraries that are friendly with each other and you have people moving from one place to another. And Anne can weigh in on this, but my feeling on this is that you have to be very careful about this. I would definitely recommend that a library talk to their attorney before they share information. I can completely see the reasoning for it. You know, libraries don't want to pass on a problem to another library. If you have a patron that maybe still owes material to you and you know that they're moving to another library, that to me gets very sticky. That other library is not your collection agency, and the other, you know, that person, it's kind of like, you know, to besmirch their quote unquote, you know, library reputation, I think becomes very problematic. So that is something that if you are in this position, I would definitely talk to your attorney before, you know, you shared negative information of a patron to another library that could possibly prevent them from getting access or prevent them from getting a card. Would you continue this for me? Thank you. Okay, I'm going to now pass this on to Anne because what I discussed really had to do with more straightforward. This is where we get into like the sexy, cool. This is where you can give information to a police officer. So I'm going to pass this on to Anne.
Oh, thank you. One of the additional elements of the amendment was to add this provision that really speaks to what you can and can't say to police officers. And I think before we dealt with this issue sort of in a indirect way, because we, talked before the amendment, we talked about what's a library record and what's not. And we determined that, a staff member's, brain and memory was not a library record, but it really wasn't very clear as to what we can say. So when this was added, it addresses it straight on. It says that the section, the Library Privacy Act does not prohibit an employee or agent of a library, remember those are defined terms, from providing a sworn statement or testimony to a law enforcement officer based solely on the personal knowledge of the employee or agent of the library regarding a crime alleged to have occurred in the library. So I want to break this down a little bit just to kind of highlight a few of the important elements. It talks about having a sworn statement or testimony. So this can be something that, it could be a verbal conversation with law enforcement. It doesn't have to be anything official. Your testimony would be a conversation that you would have with law enforcement. Police officer shows up at the library, it's that conversation. It has to be solely on the personal knowledge of the employee or the agent of the library. This is the one where I think there's going to be a lot of discussion that you have to have, maybe with your lawyer, certainly with your staff. And when I engage in something like this with a client, I also have to think about how risk adverse the library is, because you can take a position that's very strict and says basically, and we have a slide later that specifically says this. This is, and I want to make sure that the next slide addresses this, but I want to bring this out up front. This is not required. So the library has all the authority to give the statement voluntarily. The library can also say, no, we're going to require a court order before we give any information. And this may be something that you take to your library board and say, look, I want the board, to continue to have the policy that we won't give verbal, testimony without a court order. That can be the policy of your board if you choose to. It can be an individual decision based on the nature of the interest involved in the particular situation. You can decide in one circumstance to voluntarily give information, and in other circumstances decide not to give. It's a real flexible provision, and sometimes you just have, as it's human nature, we have to balance the situation at the time. You may be more willing, for example, to risk a violation of the Library Privacy Act potential, because this is new. We don't have court orders interpreting it. We don't really know where the edges are. So court cases sometimes tell us where those edges are. But you may choose, for example, if giving testimony you believe will help, bring back maybe a child that's in danger, something like that. A child was taken from the library. You may decide to give that information over to the police because there's a lot of public interest, you think, in giving that information. If it's a police officer who's coming in and they're trying to figure out whether one of your patrons is using the computer, for example, in violation of their terms of their parole, you may figure that's not really the library's business to maintain that sort of channel of communication. So it really is going to be something that one is going to be a policy of your library. Where do you really want to go with this? And then given those circumstances, how you treat each individual inquiry by the police officer. So the other thing to know is that it is involving, it is limited solely to crimes alleged to have occurred at the library. And really, as Debbie mentioned and Claire mentioned before, the whole purpose of the amendments was really to protect libraries from being victims of crime or being places where crimes are committed, and then the library's hands being tied as to prevent those. You want safe places for your patrons. You want safe places for your staff. If someone comes in and steals something from the library, you want to be able to, within the parameters of the law, be able to recover those items, or be able to assist the police with, so your library can be a safe place. So this is not a situation where you can tell, people information that has nothing to do with a crime. You have to be sort of careful because, and I understand one of the concerns when we did this was whether, the libraries would be able to determine what a crime is or not. Certainly if someone is in the library and they walk in, they, punch another patron, knock the patron out, and the police come in and ask about that, we're all pretty clear that's an assault. It's pretty familiar that that's a crime. Some of the more nuanced areas tend to be with internet use. Is it child pornography, or is it people looking at pictures of children that aren't child pornography, for example? Is it obscenity, which is a crime, or is it, pornography that's not a crime? So some of those nuances you're really going to have to, think about ahead of time. Maybe have a conversation with your lawyer. How would we handle it if the police were to come in? I think it's better to be prepared for these things. I know sort of unpacking a lot with this one slide, but I wanted to point out those particular aspects of this very important provision. So if you can move on to the next slide, please. Again, I mentioned before, it's optional. This is not something that you are required to do. You can, on an individual basis, say, no, we're not going to give it in this instance. Your library can take a position that you're not going to provide this information at all without a court order. It's within the discretion of the library, which is important. So next slide, please. So as used in this section, an employee or agent includes an employee of the library, a member of the governing body, an individual who's specifically designated as a volunteer and who's acting on behalf of the library, and any other person who's lawfully performing services on behalf of the library. I think this is really important because I think the prior law was not quite as clear on this, and this really makes it clear, for example, that members of your governing board, we always took the position, I think at least I did, that members of the governing board should not give out information. We kind of included that within the scope of libraries, but I think this is a good amendment to make it very clear. And the next slide gives you some examples of that. So obviously library employees, full-time, part-time, all levels. Your governing board is included within this. It's individual trustees or municipal governing body, depending on your establishment type. So I know Claire and I are big on this, and I don't think there's any opportunity that's too small to tell you if you don't know what type of library you are, you should find this out, because this is one of those areas where it's going to become very important. Because if you're a PA 164 city library, you have an independent library board. That library board can't give patron information maybe to the city if it's, if you're a department of the city, your governing board may be the city council. So it's different. So you make sure that you understand what your roles and responsibilities are with respect to establishment. Volunteers, this is another plug I like to give, where you should know who your volunteers are, because these are library volunteers. So these are people who have volunteered, applied for an application to volunteer at the library. You guys are in charge of them. This is not the Friends of the Library. So if you have a local, or if you have a friends group, an active friends group, they might be in the library every day, for example, manning a book sale. But the law is to get at those specifically designated by the library and acting solely on behalf of the library. And anyone performing services under a contract. So anyone who is an agent of the library through contract is going to be bound by the library privacy rules as well. So the next slide, please. So libraries should review their privacy policies to reflect how a library intends to implement the Privacy Act changes. It's interesting, I think probably since the last time I did this presentation, maybe a little bit before, I've actually had a chance to look at a few different libraries' policies. And what I've noticed is that there's certainly your confidentiality and privacy policy will likely need changes. As you know, we do model policies, and I know that for me, the model policy that I had for confidentiality had to be totally rewritten. There's enough here that it didn't make sense to do a red line copy even. So we've kind of repealed and replaced confidentiality policy. So that's one policy I think that's likely going to have issues with it. Your surveillance policy, again, that's one that I think that is going to need significant change, because most of the surveillance policies that we've drafted have at least a paragraph in there that says they can't give out surveillance video. It's a library, it's within the Library Privacy Act, and that will at least need to be amended. Because it's something that you're giving out now, you may also want to relook at the way your policy is written, because, for example, most of the policies I have, require some sort of notice to patrons that they're under surveillance. We weren't really as worried about it before because we weren't allowed to give it out without a court order, but now that it's subject essentially to FOIA, you might want to make sure that, your patrons a little bit more aware that they are under surveillance. And I think that also has the intended or unintended effect of maybe curtailing some crimes if they know they're being watched. I certainly should discuss a new protocol for providing testimony to police. I think what I noticed with libraries over the past number of years is that thinking about this when there's a crisis is not the best first time to be thinking about this. So when the police are walking the door and demand to see documents or demand to ask what happened is probably not the first time you should be thinking about what you would do or what you would say. So I recommend often getting a dialogue with your local police agency, talking with your attorney about what you can and can't say, what you may want to say, or what at least the issues will be. Adopt new procedures for reviewing contracts with vendors to ensuring vendors will possess library information that they understand and abide by the Library Privacy Act. I think a lot of you have been doing this with your collection agencies in particular. I think the co-op, the interlibrary loans are kind of taken care of because the people who run those the co-ops are, within the scope of these conversations here. But I think it's important for your vendors to understand that they are also bound by the Library Privacy Act and adopt employment policies and training to ensure that staff understand policy requirements, the ramification of improper disclosure. I've done a lot of library specific, gone to libraries and talked to the entire staff about library privacy. And, those are really good conversations to have with your staff. It's a good, half an hour, lunch in service training, because it really is a good opportunity to remind them what their obligations are and, talk about some of the bigger issues. And I think, you learn from each other, you learn from, talking about, so if when the police show up or when there's a request, sometimes it's not as jarring. All right, next, okay. This is really one of the things I really wanted to see in the Library Privacy Act, and something that's really bothered me all along is that under the old version of the act, if there was a violation of the Library Privacy Act, even if it was unintended, the employee who was the one that disclosed the record was on the hook for the penalties. And that's really unusual in Michigan law. Usually the entity itself, you're responsible for your employees, which means you're responsible for their actions while they're at the job, which would include, Library Privacy Act, inadvertent Library Privacy Act violations. So the penalties have really been divided up, and I think it's a really good change against the employee the library as an entity and against your individual responsibilities. And on the next slide, we'll start to explain the differences. So if a library employee or agent of a library violates Section 3, which is the non-disclosure section, the library is subject to liability to the person identified in the record that is improperly released or disclosed. The person identified in the record may bring a civil action against the library for actual damages or $250, whichever is greater, reasonable attorney's fees, and the cost for bringing the action. So this one, again, I want to point out a couple things. It's against the library now. It's not against the individual employee, which I think is a good thing, because again, your training should cover, should make sure that they have enough information that they're not intentionally violating the act, that it's an inadvertent violation. The issue that I always have, because that some people say the $250 and they think, it's no big deal, right? $250. I'll pay the $250 if it means, so I've had actually, people from law enforcement say that to me. I'll pay the $250. Just, we want the information. But the important part is actual damages and reasonable attorney's fees. And I know that reasonable attorney's fees might seem like an oxymoron, so, but they can add up. And so that's another thing where it can be, it's certainly going to be a lot more than $250 if you actually get sued. So that's why we want to avoid it at all costs. So that's the next slide. So the improper disclosure, again, I covered this in the last slide, but again, you want to make sure that your employees are properly trained so that you don't get into a violation. But if you do get into violation, you know, and it's inadvertent, then it's going to be against the library, not that employee. So the next slide. This is the second aspect of the penalty. If the employee or the agent knowingly violates section 3. So that's that the person who works at your library knows it's a violation of the Library Privacy Act and does it anyway. That person is then able to bring, the person identified in the record can bring a civil action against the employee or agent for those costs and fees that I already explained. So the $250 are great, it's the same language here. But again, if it's a knowing violation, if your staff member knows, you know, that it's a violation of the Library Privacy Act to give, you know, circulation records to a friend or, you know, family member, and does it anyway, that person can sue that individual and recover those same costs. So next slide. Again, it's an intentional violation was subject to the same cost. They could also award equitable relief, such as, you know, an apology, or, you know, prohibit you get an injunction against you and make sure you don't do it again. Those are the types of equitable relief courts sometimes will require. So next slide. So if the disclosure is accidental or inadvertent, again, the library is liable. If it's knowingly done, and this is important, it's likely, if it's intentional, that the library and the individual will be sued. So if your employee intentionally violates the act, be prepared not only to have a lawsuit where the library is joined, but also your specific employee. Okay, next slide. Another important change, I think, was putting a, and I think that what's interesting about this is that the changes tried to mirror kind of what the penalties are for things like the Open Meetings Act and Freedom of Information Act. You know, there's intentional violations of the Open Meetings Act and Freedom of Information Act that have different penalties, for example, but the 180 days, you know, this is about a disclosure of a record. And so the 180 days mirrors what the statute of limitations is for a violation of the Freedom of Information Act, which also deals with public records in Michigan. So we thought it was I think it's an appropriate statute of limitations. This is so you don't have something hanging over your head. Let's say you accidentally reveal a library record, you know, 5 years down the road, somebody can't come back to the library and try to file a lawsuit against the library. So it's something that has to be done in fairly short order. This is a pretty short statute of limitations, and I think it's good, good for public libraries. Okay, next slide. So what should you do? Read the new law. We always ask that you read the law, know what it says, so that you're able to answer questions from staff, from police, from public about the law. Review and revise your current policies. I think we talked about a couple of those policies. One of the questions I do get is whether you have to amend your Freedom of Information Act policy. Probably not. Unless your Freedom of Information Act policy specifically addresses surveillance. Those are the ones I've seen where sometimes libraries in their FOIA policies tried to identify certain things that they knew weren't going to be disclosed, like, you know, circulation records, and they gave some examples. That's sort of the slight amendment to the Library Privacy Act, or slight amendment to your FOIA policies, but I haven't seen too many that as a result of the Library Privacy Act have to be amended. Again, retrain your staff, including volunteers and trustees, so that they understand the change in the law and the change in the liability. And again, it's important to forge a relationship with local law enforcement and discuss the policies and information with them, and discuss it with your staff ahead of time so that everybody's prepared. So next slide, I think that might be just under the wire here at 11 o'clock. So I will turn it back over to anybody who was running the question and answer period.
Take that, Anne. So there were a couple questions that came directly to me, and I'm gonna put them out there. And I've never seen such long questions before, so I think that's maybe just very specific kinds of information is needed, you know, based on what your need is. But the first question was about surveillance cameras running in meeting rooms. And is that considered a library record?
Oh,
I'm
it's
gonna-
important. It's important to understand that meeting rooms is a little. This is a really good. I'm glad this was asked. Claire, if you want to jump in, or if you disagree, let me know. But it's really important to understand that if it's in a meeting room during like library business days and there's nothing going on, then it's treated like all surveillance records. It's a little bit more complicated if it's during a public meeting. I think you have to be real careful of that, because they might construe that as you're recording the meeting for the purposes of the minutes, which have a slightly different retention period. So for example, if you record a meeting for the purpose of creating minutes, you can destroy that record after the minutes are approved. If it's a surveillance of the video of the room for the purpose of just making sure no one's committing a crime in the room, then it's going to have a different retention period. Again, it's important to understand though too, with people coming in and trying to record themselves in the library, there's a little difference too between meetings. You can't prevent someone from recording a public meeting under the Open Meetings Act, but you can have a policy that prevents them from coming in and recording in the library during your business hours. Slightly off topic, but I wanted to make that distinction.
I think there's also, it should be noted that if you're talking about like a staff space, there are some additional kind of requirements that you're going to want to talk to your attorney about. There's some employment issues there with under the wiretapping and stuff as far as recording employees, so notice and things like that. So that's something that you'll definitely want to talk to your attorney about. So I think it might depend on the meeting room and where it is and what it's used for.
The question was really about surveillance camera running in a meeting room, where records a patron attending a specific library program.
Okay. That would be just fall under the general policy. I think, that actually raises an interesting question, because I think if it's during a program, I think you should talk to your lawyer, because I think there would be a basis to exclude it, because it shows what services they're getting from the library, just like a book, if they're attending a program. So I think that if you're surveilling your meeting rooms, I think there's going to be several different distinctions you have to make depending on what's going on in the meeting room. Claire, is that?
Yeah, I would say the same thing.
Good. Steve Bowers had to leave, so he won't be here to hear the answer to his question, but it was a little bit longer. And I know that we've had discussion with him about the vendor portion of the law, as Steve is one of the co-op directors. So, but he said lots of vendors are now offering business intelligence reports for libraries. Some are now asking for information that seems to be protected under the Michigan Library Privacy Act. Are libraries allowed to share patron checkout, what books and when, and directory information, name, address, phone, email, and demographics, and our interests with third-party vendors that are doing marketing and operations reports?
I think this would depend on exactly what that contract is. If that company, and Anne can, I'm going to throw it to Anne in a second, but if that company is creating those marketing reports for the library and the library is the only one that's going to review them, that company would be under the same restrictions that a library employee would be under as far as non-disclosure. So that to me seems like that would be okay, because that company would be on, but if that company is going to be releasing those reports to other people, then no, right, Anne?
Yeah. And they have to understand too that, because when FOIA comes into play, that, you know, those reports, you know, could be subject to FOIA as well. So they have to be careful, you know, not to release information that the library hasn't, you know, gone through as far as a FOIA request.
Mhm.
And aren't they, they're considered, you know, under the definition of agent,
Mhm.
they are as liable as the library and the library, you know, the library staff is.
But this is something that should be part of every discussion you have with a vendor, because I'm sort of one of the dangers I have with this act is that we as a library community know about the Library Privacy Act because of all the education we have. Most people in the community don't know. You probably, I suspect most of the patrons that come into your library don't know about the Library Privacy Act. I suspect a lot of vendors don't know about it. So they might not be aware of what their rights are. So I think you don't want to be in a situation where you give information to a vendor and then that vendor gives it out because they don't know. Likely, if you're sued over it, the vendor will be joined and the library will be joined. Whether you're liable for their actions is, I think, one of those things that, you know, I would hope the answer would be no, but you're going to likely be involved in the suit. So I think it's best for every library, if you're going to give that information out for marketing purposes or for, you know, strategic planning purposes or other purposes, that they understand they're under strict confidentiality rules, so that at least if there's a suit, you can show a contract where they've breached the contract by doing that. And so that's why we recommend that's a contract provision.
And while we're kind of discussing this is something that you should probably, a discussion you should have once this law goes into effect with vendors that you're already dealing with for things like shared ILSs, if you keep your information in the cloud, all of that kind of stuff. Anybody you give or who has access to your patron information you should probably have a discussion with them now that they are now liable.
So the next question is, and we'll go on as long as you're all sitting in the room, if you want to continue to join us. So we'll get through the questions, at least in the chat. If you're doing reciprocal borrowing and your requirement is that they have a valid card at their home library, can you ask that of their home library?
I would think so. Anne?
I gotta read that. Sometimes I gotta read what you're in the chat.
Yeah, if you have a reciprocal agreement, and so the rule, if you're a patron at Library A and you want to go to Library B that has a reciprocal agreement with Library B says that in order to take advantage of that agreement, you have to have your account has to be in good standing with Library A.
Good. Did that answer your question, Kat? And I don't know if she's still here or not.
Like, it's kind of a rule. It seems to me that it would be okay, but.
All right. From Peter White Library, if we keep specific video footage related to a patron's behavior or related to a specific event, not necessarily criminal in nature, but certainly related to the library code of conduct for more than 7 days in the past, is this still subject to FOIA?
So if you keep surveillance video, is it, so if you pass the 7 days, you know, after March, I don't know if you're asking about, but I think after March 31st, it could be subject to FOIA. We'd have to look at it to see whether, because that's an interesting question, because it's the video, but I think the record's still in your possession. I would think it would be likely subject to FOIA, even though it was captured prior to the end of the month. Claire, is that your understanding?
Yeah, I would think so. And moving forward, if you have certain piece of video footage that you retain and it does not get deleted after the 7 days, I would think that would also be FOIAble, right?
Yeah, and the other thing too is you know, I'm thinking out loud here, so it's always dangerous, but it's sort of what comes to mind too is that if it's part of your investigation into patron conduct, we may be first of all, it's you're not going to be, you know, I would, you know, think that, you know, there might be an argument where you could not disclose it as part of a library record if it's part of your investigation. But that's something that would have to be looked at on a case-by-case basis.
Great. The next question is, sometimes patron information is exchanged via email when dealing with overdue items borrowed via ILL. Is that information they should be sharing?
And they give an example, I think, in that, don't they?
Yeah, for example, if we lend a book to a patron or another library and it's not returned in a timely manner, the other library may email us saying, oh, the patron never returns their books on time, or that patron has X amount of overdue Melcat books right now. No specific titles or other information is shared, and sometimes it helps us figure out whether to send them an invoice or not. Is that information we should be sharing?
Well, my question is whether, I think you'd have to look to see, so this is sort of, it gets to why you're asking the question. If it's because you want to suspend their library privileges, you'd have to look to what your own policy is, because if your own policy doesn't address your overdue books from somebody else, then I think the information would be extraneous, and I wouldn't recommend that it be shared. I mean, the more common thing, I think too, I shouldn't say more common, you guys would know better than I do, but what's brought to my attention more often is when libraries want to share, you've got behavior problem patron who gets, suspended from your library, and very well they're going to go to neighboring library if they can't go to your library, and you want to give a heads up to the director. I think that would be specifically prohibited. I think some of the interlibrary loan stuff is a little bit more gray, but I think looking at your circulation policy, I think you can certainly talk to your lawyer and figure out like generally what type of information you can share and what type you shouldn't share.
Good. And two other questions. I think our privacy policy has always just been a copy of the Library Policy Act for Michigan, not something separate. Is this okay?
I think it depends. I think it depends on, especially with the new law, what your library wants to do, whether they want to take advantage of the disclosure portions or not. And I'm going to throw it to Anne in a second, but it would seem to me that it would be a good idea for you to have a little bit of a more specific policy. But
well, so there's nothing in the law, and Claire, remind me of this. I don't think there's anything in this law that requires you to have a policy. For example, the law requires you to have a FOIA policy. It requires you to have an investment policy. There's nothing that says you have to have a confidentiality policy. I recommend it because I think the Library Privacy Act is too hard to digest for your typical patron. And your policies are for you. They're for you to protect yourself, but they're also for the patrons to understand and I think the policy to me gives a clearer, more user-friendly explanation of what their expectations should be for privacy in the library and what their expectations should not be. So again, not a requirement, but I think if you were going to have a policy on it, I think just putting the Library Privacy Act in place probably is not going to give you the benefit you need from that.
Right. And the same for your staff. I mean, the privacy policy would encompass, your staff behavior as well.
How do we work? What's the procedure? What do we do now? Right. Yeah. So, and I think the last question that Claire actually answered in the chat, but just to make sure that everybody is aware, the law is for more than just public libraries. It is for school and academic libraries. And if you go read the act, because it does state that at the very beginning. And I think even when we first brought that to our own attention in October of 2019, that we all didn't recognize that either. And we did have a lot of conversation about how that affected not only our public libraries, but our school and our academic libraries as well. I think that's all the questions that we had. And I want to thank Claire and Anne. They're our experts. They're the ones that they have digested this and they can spew it out and hopefully you've gained lots of great information. And I think that we're all available to take questions up until probably the end of March and even after that for the things that you're encountering. But make sure that you take this if you have other questions to your specific attorney for your specific library. I think that's always the best advice that those two give us. So, but I think there was an evaluation. Claire, was that on the one of the last slides?
Oh, no, that,
is that for the other one?
right. Yeah, I'm sorry. I should have taken that off. That wasn't yours.
Good.
That was my error.
All right. Well, great. Well, thank you all for joining us. We're really pleased that you were with us. And like I said, if you have questions, the three of us are able to answer. So thanks for joining us.
Thank you.
Thank you.